to Privacy Download. My name is Irina Anyukhina, and I'm partner at Al-Rud law firm, full-service independent Russian law firm based in Moscow, one of the leaders on the Russian market on data protection and cybersecurity. Today, I will be talking to you about key requirement of Russian privacy laws, data localization requirement. Russian privacy laws are mainly based on the Convention for the Protection of Individuals with regard to automatic processing of personal data. Key provisions of privacy laws in Russia are to a great extent similar to those under the EU laws, including the GDPR. This is true, for instance, for legal grounds of data processing and general principles such as purpose limitation and data minimization. Of course, many aspects exist in enforcement practices, but the fundamentals of privacy laws in Russia will likely be familiar for companies and lawyers working with the GDPR. The key privacy act in Russia is Federal Law on Personal Data, which sets forth the legal framework of processing personal data and outlines key requirements towards ensuring data privacy. Data protection compliance in Russia is based on the so-called data localization requirement, which may be called the business card of Russian privacy laws. This requirement obliges controllers operating in Russia to use local databases for personal data processing. The localization rule is mandatory for all companies operating in Russia, both local and international. It also applies to those companies which target Russian market, Russian consumers, even if such companies do not have formal point of presence in Russia. It applies to all ways of processing, both online and offline, and covers all industries in which company may operate. Thus, it is in the spotlight in all cases of interaction with consumers located in Russia and other business activities on the Russian market. Failure to comply with the data localization requirement may lead to administrative fines up to approximately $250,000 and even to blockage of companies' web resources like websites or mobile apps in the worst case scenario. What does Russian data localization requirement mean? It means that upon collection, certain operations with personal data of Russian nationals should be performed in the databases located in Russia. In other words, once personal data are collected, they should be placed in a database located in Russia, the so-called primary database, so that operations on the data are carried out locally. Once so done, the data can further be transferred abroad for further processing to a so-called secondary database. Localization rule does not prohibit cross-border transfer of personal data. Such transfer should be formalized based on a data processing agreement, implementing legal measures to preserve privacy and ensure security of personal data which are transferred, as well as implementing formal internal data protection policies and ensuring an appropriate legal ground for data transfer. The data localization requirement became effective from 1st of September 2015. One of the first and the most well-known cases was the blockage of LinkedIn website in 2016. This website is still unavailable for users in Russia. The administrative fines at that time had been significantly modest, but in 2019, they were largely increased up to approximately $250,000 per breach. And the regulators started to enforce the fines against different businesses operating in Russia. Twitter and Facebook, they do not have presence in Russia till now, but nonetheless, they were fined for approximately $55,000 each, and the regulator doesn't exclude that enforcement will continue until data collected on the territory of Russia is duly localized. It is fair to say that it is possible to challenge fines for data localization in courts, but the current court position substantiates the position of the regulator. Now, in order to be on the safe side, companies must be ready to evidence use of local databases, at least in part related to data of Russian nationals. Sufficient evidence in this regard could be rent of server facilities in Russia or purchase of servers from Russia-based suppliers. Additionally, specific localization requirements are being currently developed in sectorial and industrial legislation. For instance, communications providers in Russia are obliged to store certain traffic data in the territory of Russia. There is also a draft regulation regarding the local storage of accounting documents, and similar initiatives are currently discussed in many other industries. The localization requirement has become a great challenge for many foreign and international companies operating in Russia in terms of their IT infrastructure deployment, restructure of IT operations, investing rather significant resources in order to be compliant by way of renting server facilities or migrating to local solutions. This trend is likely to continue in the future. It will be fair to say that the market offer of local data centers and Russian cloud solutions has significantly increased. What are the key takeaways? The first key step is to define whether your particular operations on the Russian market or targeting Russian audience fall under the localization requirement. Operations may be rather complex, multi-jurisdictional, which does not necessarily mean that all such operations fall under the data localization requirement in Russia. Quite a lot will depend on the particular aspects of IT processes, transfers, types of data collected, ways of processing, and so on. Think about discussing this issue directly with your local data privacy expert in Russia. Then, if the localization requirement applies, the next step would be auditing the company's personal data processing activities. Such audit allows to identify how the data flows are structured, what information systems are used, and what data in particular fall under the localization requirement. The results of such audit may be extremely helpful for the optimization of restructure of certain operations with due regard to localization rule. Specific localization solutions and legal ways to mitigate the risks could be worked out as well by your local data privacy council. Please do not forget that data protection internal policy containing measures which are implemented by the company in Russia, it is a mandatory local policy. It should be also deployed on the website of the company to ensure compliance. Think also about regular monitoring of localization compliance on operational level. Each process that implies international data flows must be assessed from that angle. The same is true for the software used by the employees of the company and contractors, customers in their day-to-day operations. On a contractual level, related risks could be minimized to a large extent by inclusion of specific terms into the agreements with service providers and contractors. I do hope that this information has practical meaning for you. If you have any questions or may need any additional information, you are welcome to reach out to me. Myself and our team are part of international community of leading privacy experts of GALA and IAA, and we handle both local and cross-border data privacy issues. I will be glad to assist you in Russia. Wishing you all the best and have a very nice day ahead.